window, so we'll have an opportunity. If you want to make a comment, please, you can use the chat window for the comments that you will be having. We'll be having 3 presentations. I would love to let you know from the onset that after every presentation, we are going to open up a poll, and the poll will be, we'll be launching a poll, and the poll will be looking at how you feel the presentation has improved your understanding of the efforts required to strengthen customary land tenure registration. So we'll be launching the poll, and it's a yes or no. So you'll be letting us know how you feel the presentation that would have come through has helped you get a better understanding of registration of customary land tenure or of customary land. So that is something that we hope to be doing in the process of processes going forward. So I'll let you know as and when that comes up. I want to take this opportunity to welcome all of you to this meeting. Susan, Brian, Collins, Douglas, Elliot, Francis, Frida, Irene, Isaac, Jesse, Jonathan, Ochom, Juliet, Lydia, Nuriat, Daniel, Rebecca, Peter, Samuel, Susan, and everyone that will be joining us later. We're going to be having our panelists today. So we'll be having Mrs. Sarah Kulata Basangwa. Please welcome. We'll be hearing from Mrs. Sarah Kulata, who will be making a presentation later on. Ms. Judith Atukunda from LandNet will also be making a presentation, and we'll be having Mr. Kambugu William, still from the Ministry of Lands, who will be making a presentation. So that is how we are going to go forward. Please, give me 1 minute so we can allow in other attendees, and then we can have the session start. Thank you so much. Welcome again, ladies and gentlemen. So we're going to start our webinar. Our panelists are ready to start off with the webinar. Maybe as a bit of an introduction to today's webinar, we are still looking at excuse us for the technical glitches. We're not in control of the technology, but we know that we'll have this fixed. So please. So welcome again. We are having a discussion around laying the foundations for a customary land registry for Uganda, where in this effort we are looking at engaging the different bodies of land actors, policymakers, customary, community and academia to examine issues around customary land tenure regime. And for this effort that we are doing for laying the foundation for customary land registry, we are looking at the contemporary legal and spatial issues in Uganda, or particularly on customary land tenure. We already started the discussions where we are looking at a working group supporting the Ministry of Lands, Housing and Urban Development to be able to have discussions around having a customary land registry. So today, for this particular webinar, where we'll be discussing the contemporary legal and spatial issues in Uganda on customary land tenure, we are looking at the various, we are looking through the various research trainings and conferences that LandNet has been hosting, where a majority of the stakeholders in the lands, housing and urban development sector are not well versed with the contemporary issues and current trends in the legal and spatial frameworks for the administration of customary tenure. There are also various misconceptions as to whether the land law in its current form has been able to offer security of tenure for customary land owners, bearing in mind the strong propositions by the Constitution to uplift customary tenure to be at par with the other three tenure systems, that's the Mailo, the freehold, and the leasehold. We know that in all these discussions, especially around regions that are affected by the conversions of customary tenure, but also all these struggles that are happening on land, on customary land, we know that there has to be a discussion around the legal and spatial issues with regard to this kind of tenure. When we talk about the legal, we're talking about the Constitution, the Land Act, and other tenant laws. But the spatial, we also talk about now the actual definition of land and land holding and its registration wherever this customary land exists. So today we have an opportunity to have that discussion, and we're going to have three presentations. The first presentation is coming from Judith of LandNet, where she'll be talking about learning from the past, emerging spatial issues in customary land registration. Please welcome Judith to make the first presentation, and she'll be sharing her screen for all of us to follow. Thank you.
Good afternoon, everyone. Welcome for this webinar and for the first presentation. My name is Judith Atukunda, and I work with Land Uganda as a surveyor. So I'll be taking you through the topic, learning from the past, emerging spatial issues on customary land registration. What we started with was to look at the registry components if we are to have a land registry for customary land. The first one is having the legal attributes. This could include the owner's name, the interests on the land, the rights, as well as any other information that can be related to a parcel. And the second being the reference, the registry map or the cadastral plan. And this one basically shows us the shape, the size, and the location of the parcel. Yes. So we also looked at the steps of establishing a land registry. What would we need to do in order for us to establish a functioning land registry for customary tenure in Uganda? First was the initial determination of existing rights. This includes adjudication, finding out who owns what kind of parcel, the extent, basically the adjudication stage. Then demarcating and marking the limits of each of these ground, each of these parcels on the ground, and then surveying the land or measuring it precisely to establish the coordinates of each of these points and the extents of the land parcels. And then also description of land parcels and then tenure rights that are attached to each of these parcels. So we looked at two kinds of cadasters, that is the physical cadaster that is mainly for taxation purposes, and the legal cadaster that we run here in the country, which is for purposes of land registration. And we agreed that we need a cadastral survey, or we need a cadastral map in order for us to properly set up this kind of cadaster. So what we have currently, this has been done for the 3 tenure systems, that is the Mailo tenure system, the freehold tenure system, and the leasehold, but not for customary tenure. So we went ahead and identified some of these challenges and that are on customary tenure that are basically spatial. And one of it was us not having a complete cadaster or an incomplete cadaster, where you have some of the parts of the country having cadastral sheets covered, while the rest of the part of the country, which is mainly covered by customary tenure, not having these cadastral sheets. So that is something that we need to think about and something that we need to look into if we are to have a complete cadastral coverage for our country. The second challenge that we looked at was data integration. When you have data that is captured in different systems or that is captured using, for example, different standards and measurements of accuracy, there would be trouble trying to overlay this data or trying to have it exist in a unified system. Yes. An example I can give is parcels of land on Mailo that have been captured under the registry as it is now, and those parcels or sketches that are captured on customary land. Such data is hard to integrate. It poses a great problem when it comes to integration of that kind of data. So that is another spatial challenge that we identified that is on customary land that we need to look into and discuss and find a solution for. The third one is the challenge of the PIN, the parcel identification number. Currently, on customary tenure, the kind of system that we use for identification is based on a district, based on a sub-county, or on the village. All these have codes. So a parcel is identified based on which village, sub-county, county, and district in which it falls. And this, as compared to volume and folio or plot and block systems, might not be sustainable in a way, in that we have seen new districts being created, we have seen new sub-counties being created. So what then happens to the identification of this particular parcel that was in one district before and then now in another district. So we need to look at how this has evolved and how we can keep working towards that integration that we require for customary tenure and having it at par with other tenure systems, but focusing on the special needs of this kind of tenure. The third challenge that we looked at is that, well, we have had the geodetic control network extended for at least almost the whole of Uganda, is very well covered. So we need to tap into this to make sure that all the cadastral parcels, for us to have a complete cadastral coverage, are linked or are based on a unified system. This is something that we can tap into, and this has not been done for customary land tenure. So it is something that we clearly need to look into and address. So the fourth, which couldn't be a very, very big challenge, is the spatial reference system in which we work. We need to discuss the systems that we have in Uganda already. It could be global, it could be a local datum that we use, but then what we can base on for even subsequent survey operations on customary land. Having it into not only into the system, but also discussing what happens then next after we have done the initial mapping and inclusion of the customary land tenure into the National Land Information System, which is now our unified system of land administration. So the future, what did we envision for the future is that we need to have integrated tenure systems. All the 4 tenure systems have been recognized by the Constitution, yes, as being equal and that they can exist. So what we need to do is ensure that we have a complete spatial coverage, and that is by finding ways of how we include customary tenure into the system, and then also join forces by different land actors. There are very many. There are surveyors, there are planners, there are lawyers, there are very many actors. So we need to join forces and forge a way forward of how we can have this tenure preserved, but also made to coexist with other tenure systems, as we can see from the illustration there. Then also streamlining of the laws. Yes, there are still those hiccups in the laws that need to be addressed that will then help us move forward with the tenure system. Thank you very much for listening. That was my presentation. Over to you, Mr. Mwebe.
Thank you so much, Judith. Thank you so much for providing the insights into the spatial learning from the past and the emerging spatial issues in customary land registration. Well, for the benefit of everyone on this call, we needed to first have a presentation on the snapshot on ongoing initiatives for registering customary land, but we're still very challenged with the person who's supposed to provide the keynote address. And that's why we had this presentation before the first one. But now I want to take the opportunity to invite Mr. William Kambugu to present a snapshot on ongoing initiatives for registering customary land. If it's in our interest, we can always bring back Judith to go through 3 or 5 minutes, because then now we need to still have a bit of a refreshing of what she has been talking about. So Mr. William Kambugu, please welcome, and please take us through a presentation, a snapshot on ongoing initiatives for registering customary land.
Thank you very much. My name is Kambugu William. I work with the Ministry of Lands, and I'm in the IT unit of Ministry of Lands. I'm going to look at what ongoing activities with registering customary land. And as you may note that we have 4 tenures recognized in the Constitution. And when you look at that map, most of the customary tenure is in the north, south, western, and eastern Uganda. And part of those districts, they have communally owned kind of land rights. So they have a common objective towards the use and their land rights. So the status of the Uganda Land Information System in terms of the customary tenure, as you can see the figures, areas of customary have the least registered properties within the system. And also when you look at the areas where we have other tenures like freehold, Mailo, and then leasehold, their registration is high. So that means that there's something that is not happening when you look at this area. So we need to have the customary tenure reflected. That's what we are thinking of, that if the Uganda NLIS can have also the customary tenure part of the UGA NLIS, I think it will be very great for
William. William,
yes,
for a minute, please talk about please avoid acronyms because not everyone knows UGA NLIS for purposes of everyone on the call. Thank you.
Okay, thank you very much. When you look at the National Land Information System, which has been developed based on the global concept for land administration and management, you look at the areas of the north where the customary north, the east, we have the lowest registered numbers within the systems. And there I'm talking about the freehold and leasehold, because the coverage, the biggest coverage is customary tenure. So looking at how can we extend services to the communities up to the sub-county level, we need to think of how to bring in the customary registrar on board. But looking at providing services from the area land committee, sub-county, up the district land boards. So maybe we shall use through geoportals, as the ministry is coming up with public and corporate portals, so that the communities can have access to their land services. So the current management of customary land, this is how it is, that we have different teams come up with innovative ideas and developed land administration tools for data collection for customary. We have the STDM, which is doing well. We have the CRIPS under GIZ, which is also doing well. But also the ministry has come up with an initiative of having the Slack tool to enable business continuity when some of these projects have ended. But when you look at what is happening, there are challenges. How are we going to secure the customary data? Or it needs to be thought about. How will the communities access this data? That's also, we need to think about it. That from the sub-county level, up to the district level, and then up to at national level. So when you look at the UGRIS operation to the customary, there's still more to be done, because we find that we need to think about how the subsequent transaction will be performed from the sub-county up to the district level. So there's more to think about. So when you look at all tools designed, I've used the Slack tool as a case study, you find that they have similar services they are providing in terms of data management, from data collection up to the issuance of the customary certificate. But you find that there's need to integrate all this collected data and efforts into the Uganda Land Information System. So we have, how shall we integrate all the services into those areas, and we secure the data, but we ensure there's business continuity. So this is still the interface. This is how most of the tools are from capturing the parcels and then recording the natural person and then the legal person. So all the tools have that capacity. So when you look at other activities within the ministries, we have come up with the Uganda, the geodetic reference frame. So to support mapping. So we need to give a common framework based on the georeferencing of all data from all the land tenures, including the customary. This we think shall support the seamless cadastral system for all tenures, and also to try to avoid overlaps of the different land parcels from the different tenures. So we need to bring the customary layer into the UGLIS, but how would it be done? Because a lot of is happening. Even some sketches are still being used. So how shall we migrate data? And then also how shall we protect the land rights, since most of these land parcels are not based on the common base provided by the UGRF, the geodetic reference frame. So we need to think about that, because the ministry has established 12 cores and all managed at the central server. So we need the customary tenure to tap into the initiatives which are being done within the ministry. So when you look at the future of your Uganda Land Information System, we are looking at how we can migrate all the data, the CCO data, to the Uganda Land Information System, and that's looking at all the tools. And also we are looking at how shall we perform the subsequent transaction. As you know, the infrastructure from the district to the sub-county is a lot of impediments. So how shall we enable that? And also, how shall we support the data capturing and processing at the sub-county? Because when you look at the sub-counties, there are many in Uganda. So how shall we extend services to the communities? And also, how shall we have a secure access to the CCO data by the communities, because they need to perform most of the activities on within the customary land management tenure. So we need also to think about, so that's we're thinking of how we can incorporate all these activities to support the customary tenure management. So when we borrow from the global approach for land administration, we are looking at issues of the land tenure, land value, the land use, the land development, and how shall we make an effective land use management. So how can the registration of customary lands adopt this modern approach? Because when you look at this modern approach, it's what the UGLIS is based on. So how can we support the tenure, the customary tenure, to use the global approach for sustainable development? So also there's a lot to think about. So when you look at the concept of a multi-purpose cadastral system, we look at having land use still development, the cadastral and taxation basis, because within the areas of customary, all these activities will be available for economic development. So we need to see how can we achieve this. So today, as you see, we have the Mailo, leasehold, freehold integrated, but the customary efforts are not yet integrated to be part of the entire land management, the Uganda Land Management Information System, which we think is reliable, because all these registers which are into the UGLIS, we think that if the customary register is part of the UGLIS, the Uganda Land Information System, it will make a lot of sense, because we need to integrate with different layers, among others. So this question remains with us, the technical people into land management and administration, because the the customary tenure register is a little bit hanging somewhere. So how can we integrate it with other tenures which are recognized by the institution, so that the communities can have tenure security in forms of the registration, and also in form of the data integrity. So how shall we maintain that we can keep track of who has captured the data, when was it captured, who signed off this transaction. So all those are to be thought about. Thank you very much. That's what I had for you today.
Thank you so much, William, for your very thoughtful presentation. It triggers very many questions. I know that part of the discussion is bringing out questions of particularly how we can migrate data for data on certificates of customary ownership from the different tools that you've put out, Slack, STDM, into the Uganda National Land Information System. And how do we enable this? How do you support the data capturing in all the different sub-counties that is happening? That's a question that's coming up. And I believe that when Judith comes on later, these are some of the issues that she'll be also highlighting. The other thing that you talk about is the multi-purpose cadastral system, where the Mailo, freehold, and lease are integrated, but the customary tenure isn't. If the registry is a part of the LIS, the Land Information System, it will make a difference. This is how can this be integrated? It's a question that's coming up, and that would love to hear more about. For all the participants on this call, we want to get your feedback on a particular session and how it's been useful to you. So we're going to launch a poll, which is having one question with a yes or no that says, has this presentation improved your understanding of the efforts required to strengthen customary land tenure registration? Please look into your window, you'll see the poll, and please go ahead and give us a yes or no for this particular question that has come through. So thank you so much, William. I want now to invite Mrs. Sarah Kulata. William was talking about a lot of the technical work that goes into the registry. Now we would love to hear from Mrs. Sarah Kulata, providing the legal lens, reconciling the land laws and policy with the past and current customary land registration initiatives. Please welcome Ms. Sarah Kulata. Please go on with filling out the poll as we go on with the session. Thank you. Hello, Mrs. Sarah Kulata.
Hello.
Please, we welcome you to make the presentation. Make your presentation, please.
Thank you very much. Unfortunately, I got an interruption, so I missed part of Mr. Kambugu's, the biggest part of Mr. Kambugu's presentation. Good afternoon, everyone.
Good afternoon.
My name is Sarah Kulata. My name is Sarah Kulata Basangwa. I've had over 30 years doing land registration, but now I'm doing consultancy work, and inevitably I'm asked a lot about land registration issues. I thank you for inviting me for this, because it is good if the whole country, as Judith and Kambugu said, get registered. You requested me to talk about reconciling the land laws and policy with the past and the current customary land registration initiatives. I'm not going to history because that one has already been talked about, that before the colonialists came, our land was basically owned customarily, but the custom changed from area to area, communal, clan, tribe, family. But when the colonialists came, they intervened and made treaties with organized communities, Buganda, Tora, and Ankole, and established land registration, not taking into account the customary holdings that we had then. They introduced Mailo in Uganda, and Ankole and Tolu, they introduced the native freehold, which was not alienated into those. And the customary occupant on this at will about this land and the occupant. And the only compensation that the get would be for the development on the land and for the crops till you harvest in the next 3 months. So the customer tenant was just a tenant in 1969. Public attempt to issue titles to customary owners under a project of adjudicated freehold. Pilot projects were done in Bushenyi in the counties of Igara and Shema, in Rukunjiri in the county of Rujumbura, Kabale in the county of Ruchiga, and part of Chisoro, and also Mbali. This registration was systematically done. They did systematic adjudication, demarcation, surveying, and titling for all the land in that county, in those counties. Even then, the project was resisted in some areas of the country. And it would be interesting for the participants to know that most of the titles that were issued to the customary owners under these adjudicated freehold have never been picked from the titles officers from 1958 to date. So as we are thinking of registering land customarily, let's know that some people are not interested. They may never pick this document. They may not want to look at it because they think that customarily their land cannot be registered. In 1969, the law slightly improved the recognition of the customary owner, with the exception of land in Uganda and the urban areas. Most land in the country that was owned customarily remained public land and was lawfully occupied by customary tenants. However, it could no longer be alienated without the consent of the tenant. If a person was interested in any such land, if you look at the old land application forms to register land, they would have a clause whether the land is occupied. Did you get the consent? So at least that was some protection. So in addition, this law also provided that the occupant could apply, the customary occupant, customary owner, could apply for a right to lease the land. But even then, this was a certain fees. in 1975, did away with all this protection and declared all land to be public land and abolished all the three tenure systems, Mailo, freehold, and leasehold. Regarding customary tenure, this law not only did it remove the legal protection, so made it criminal for a customary owner to occupy land without government license. And this offense was punishable by imprisonment of up to 1 year. This period, 1975 to 1995, the customary owner became a tenant at sufferance. Indeed, some of the customary owners complaining now of having been evicted and what were done so in this period, 75 to 95, because they didn't have any say whatsoever. Let's come to the present. 1995, tenure systems adopted ownership as a fully fledged tenure to own land in perpetuity, like freehold and in Mailo. However, the law says a customary owner can acquire a certificate of customary ownership. A certificate of customary ownership, not a certificate of customary title. The issue of issuance of a customary title comes in with a proposal in the National Land Policy. So, to make this customary ownership at par with the other tenures, ideally there should be a title. So, ideally there should be surveying. And Judith is right when she talked about that these after survey, these records should be able to be integrated in the National Land Information System. In order to implement this, some pilots have again been done with systematic demarcation regarding customary land. I'll talk about the one of Lukalango in Ntungamo and one in Aminiti in Soroti and in Bunyoro and what. But it's interesting that in Ntungamo, the idea was holding is more individualized than family land. But in Aminiti and Soroti, it was rejected to the extent that we nearly had deaths of our staff when they went to do the systematic demarcation. So under Policy Statement 39, government is saying that they shall recognize the customary tenure in its own form to be at par with the other tenure systems, and that they shall establish a land registration system for the registration of land rights under the customary tenure. The policy provides for various strategies for achieving this goal, and these are facilitating evolution and development of customary tenure by establishing its registry, legislative review, and strengthening the traditional land management and administrative institutions. In summary, I'm saying that pre-1900, customary owners had user rights and they didn't have, there was no registration initiative. 1900 to 1969, the customary owner was a tenant at will, and government tried adjudicated freehold, piloted, successful in as far as issuing titles was concerned, but the titles are still not collected. 1975, the customary owner became a tenant at sufferance. From 1995, the customary owner became king because now customary ownership is recognized. However, this king requires to get an appropriate crown. And to get this, in my opinion, to put the crown on this king requires laws and regulations to be in place. I thank you very much for listening to me.
Thank you so much, Mrs. Sarah Kulata. A very informative discussion, looking at the whole understanding of the spatial and the spatial issues, but also how they fit in the legal framework, and how they fit in the legal framework. Interesting to note are the two observations of the law providing for certificates of customary ownership and not for certificates of customary title or customary certificates of title. And noting that this was just a proposal in the National Land Policy, which is yet to really happen. Mrs. Sarah Kulata notes that some people are actually not interested in the registration of land, but also the other discussions around registration and conversion of customary land. That is a discussion that is ongoing. She brings out the issues in Tungamo, where people were embracing the more individualized and the bit of the family registration, while in Naminit Soroti, this was something that they wouldn't really take. And now, citing the policy statement 39, which talks about establishing a customary land registry. These are very, very good issues to ponder upon, and also to look at how the legal speaks to the spatial issues surrounding registration of customary land. I can see many questions in the chat window, in the Q&A window. I hope that Mr. Kambugu takes note of them, and I know that some will also will be going to Mrs. Sarah Kulata. If I could highlight like two of them. One, is the framework of customary land registration skewed towards making it easier for land transactions? There's almost nothing about protecting land rights. That is a question that we could send to Mrs. Sarah Kulata, because then it gets into the bit of the legal and use of land. And then to Mr. Kambugu, there are a couple of questions that are coming through. We talk about what extent have the fit for purpose tools helped in registering CCOs. How many CCOs have been registered so far? The one of if customary land titles were made in 1958, what procedures and reference systems were used? Does this mean that the customary tenure is in the registry? Interesting questions, and I know that we'll have an opportunity to answer back to these questions. I want to, for purposes of the presentation that we've just had, I want to open up a poll on the presentation that we've just had from Mrs. Sarah Kulata. And the poll still is the same. It says, has this presentation improved your understanding of the efforts required to strengthen the customary land tenure registration? Please put your yes or no, and we'll see how this goes. Okay, so the poll is open. Please go ahead and vote as you deem fit. So at the start, we had an issue with the technology. So we had a presentation that was to come second. I want to use only 5 minutes to be able to give an opportunity to Judith and Stella Maris to respond, especially to the spatial issues regarding registration of customary land. And this will be leaning on their presentation that was learning from the past, emerging spatial issues in the registration of customary land. Please, Judith and Stella, take 5 minutes to react to what Mr. William Kambugu shared, and then we'll be able to go forward with the session, the plenary, with the questions and answers. For anyone with questions and answers, please use the Q&A window, but we'll also have an opportunity to have questions asked. Mr. Okot Emmanuel, the presentations will be shared with all of us, so please rest assured they will be shared. Judith and Stella, please pick on from here.
Thank you very much, moderator, and good afternoon once again. I will just make a quick comment from the questions that are appearing in the chat and also the Q&A section. So what I can say is that Uganda runs two systems alongside each other. But the major one that we know is the terrain system, one that uses the fixed boundary approach. And this is what the three tenure systems, that is the Mailo tenure system, the leasehold, and the freehold system, are kind of anchored on. The principles of that system is what we use, or is what is used in the country when we are surveying and registering land on those tenure systems. So this is different from a general boundaries approach kind of system that is used on customary land. So if we are going to merge these two, or if we are going to integrate these two systems, there are things that we need to address. Yes, like I highlighted in the presentation I made earlier, things to do with the PIN, the personal identification number, things to do with the reference systems that we use that need, also keeping in mind the kind of organization or the social fabric of the customary tenure system. There are things that we need to address according to that system. So these are decisions, like the moderator said, that we need to both agree on, that we need to both address and make a decision for what takes us forward. When you look at the difference that Mrs. Sarah Kulata highlighted of you having a certificate of title, how you acquire it, what are the survey procedures and other procedures, and also that certificate of customary ownership, it is different. So we need to look at these issues, and we had highlighted on streamlining of laws, the survey laws, the data collection laws, and everything that is embedded in there. But yes, we have to make decisions on those. They have spatial implications, very big spatial implications, that then we have to agree on for us to move forward. Then there was a question on, I think that would be best answered by Mr. Kambugu about what the current efforts on registering customary land, on using fit for purpose approaches for surveying. Mr. Kambugu will help us answer that. But yes, registration of land, also on a bigger picture and maybe global overview, comes with very many importances or very many positives. Yes. An example I can give is the different issues that are happening on maybe customary tenure. Things of you can't have clear boundaries, things of I can't retrace my boundaries, I can't open these boundaries. It is because of it not being able to be referenced, for example, on a geodetic network that is uniform and that you can always rely on and use and compute in case you need to readjust, or in case you need to re-establish some of these points or boundaries. Yes. So that is all I have to say, but my colleague Stella can add in something there if she has to. Thank you very much. Thank you, moderator.
Thank you, Judith. The other thing, Judith and Stella, there was a whole discussion around the various tools and that are being used to capture information on customary land, and how to have all this information migrate into the NLIS. And I know that as we talk about learning from the past, the emerging spatial issues in customary land registration, you could have a comment around that, especially as LandNet and the work that you've been doing in this field. What does it, what are those challenges that it poses?
Thank you very much, Mr. Mwebe. So about migrating that data into the NLIS and the different tools that are used, it should be an open conversation, really, but like we have presented to you, yes, there are those nitty-gritties that you need to look at and put into consideration. So surveying, the good thing with technology is that it will offer you very many alternatives, yes? But those standards of accuracy will still be required for you to establish something that is reasonable. GPS technology is very good, and it's evolving, and more technologies will come up. But what we need in this case are decisions that we need to make on what is putting us forward. If you want customary tenure to be at par with the 3 tenure systems, what then needs to be done? Yes. So this data and collection accuracies can be improved. We can, if we are able to establish standards of what kind of accuracy you can collect with any tool, you can collect with any technology. Even other technologies are going to come because it keeps evolving over and over again. But we need to discuss and agree on things like that. Yes, on the requirements, on the nitty-gritties. If you're having a certificate of title on customary tenure, what is it going to look like? What are the standards? What are the minimum requirements for the data that we are going to collect with any tool that you feel like you can access, or any technology that you can use to collect that data? That is my comment about that. Perhaps Mr. Campbell, yes, we'll have something to add on that. And thank you very much.
Okay. Hello, everyone. I was initially not supposed to be on this, but my presence has pulled me inside. So only to add on that we are talking about decisions, and we believe that decisions in our country are driven by the law. So even when we have technology advancements, even when we can do all these integrations as spatial experts or people who are trying their best to make sure that there is an integration in the data system, still there is need to reform the laws to make the laws suitable and very equitable for the surveyors and all other people in the geospatial industry to work. For example, the survey law, the RTA, the Land Act, all these have constraints at one another that need to be harmonized to establish a platform generally for us to perform our duties. I think I bring the mic back to you, Mr. Mwebe.
Thank you so much, Stella Maris and Judith, for the additions to the discussion. Now I know we are open to questions and comments from the people who are attending this session. I want to first go through some of the questions, and I know they are directed towards Mr. Kambugu, so that you can have some answers as we also figure out the other questions that will be coming from the attendees, because I noticed that there are some arms that are up. I want to go to the chat window and pull out some of these questions. What is the importance of having a complete cadastre to land registration, and particularly customary land registration? Why do we need a complete cadastre or land registration, and particularly customary land registration? The other question is from Frida, that was from Rebecca, now from Frida. I have noticed that there are very many land tools used during registration of customary tenure, like STDM, Slack, name them. We need to harmonize all these approaches. That's a comment, I guess. From Jordana Ukobak, she says, why then is the ministry encouraging registration of customary land when there is no land management system in place? How are you going to track subsequent transactions? Do you think you need to harmonize all these issues before the issuance of CCOs? That question still is pending. Why does the ministry encourage registration of customary land, yet there is no land management system in place? How are you going to track the subsequent transactions? The other is, okay, I'm just, let me get to the Q&A section. So, Mr. O.P. Francis, some customs give land to the eldest son, through inheritance, where the other family members protected if the eldest son decides to register land as his. I think that would go to Mrs. Sarah Kulata. One, the other is key issues to be answered in regards to customary land titling or registration is how different is recordation or documentation as it is now as under the other three tenure systems. What endpoint are we seeking to achieve from the shift in documentation to registration? Okay. From Frida, because land has been a profitable business to many today, even those who would want to have documented evidence of ownership of their customary land are in great fear. What means can we use to enhance sensitization and awareness to support communities to have their land registered? How can you enhance sensitization and awareness to support registration of land by communities? The other is, are the communities aware of the importance of changes that are being premised regarding the need to upgrade customary tenure? Are communities aware of all these initiatives around registration of customary land? Maybe the other is, okay, let's go with those. Yes, let's have an opportunity. Brian Makabai, in my view, customary land data to be easily incorporated with other tenures in the NLIS, they should all use fixed boundaries. This would, however, make surveys on customary land expensive, a thing we wouldn't want. Use of geodetic GPSs with the current Ministry of Lands would help. The law, however, still states that customary land uses general boundaries. Oh, that's a comment from Brian Makabai. And lastly, if customary land titles, oh no, we read that. So Mr. Kamugu, please address some of these questions and Mrs. Sarah Kulata as we go forward. Thank you.
Thank you very much, Mr. Mwewe. I will start with why is the ministry encouraging registration of customary land? Yes, the ministry is encouraging the registration of customary land. However, it is trying to see how can it make the customary registration more secure, in a secure manner, that all the records and the data captured are very secure, which is not for the case today, but we are trying to see how best can we do it, because if we didn't start, we wouldn't realize some of the issues we have of to date. So there's another issue of how are you going to track the subsequent transaction? Well, when you see the Mailo registry before the digitization, we converted all the land the land documents plus the titles. So we with that experience, we shall be able to do data conversion for all the existing customary data, and then the issued certificate of customary into the LIS, and then for any other subsequent transaction, we are looking at coming up with the guidelines, but still, what does the law say? We need to follow what is implemented in the law. Who does these transactions? It's done at the sub-county. So when we are developing the system, we need to develop it we need to develop the system relating to the law. So, so yes, there's a need to harmonize issuance of customary issuance of all the customary certificate of titles, because reason being that we need to know if I am in Noya, if I'm in Kasese, if I'm in Kabale, I have the same copy of certificate, I have the same, the template is the same, and you should be able to access the data, and all these tools which are developed already. We shared the data catalog, which they develop using the LIS data catalog, so that at the time of migration or integration of the records within the LIS, they can really be compatible, because the data format has to be the same. And then we have another question about the global, how to have a global, the benefits of having the global land administration approach, because we are looking at sustainable development for these areas. So if you look at sustainable development, we need to get all these modern, the modern aspects into place. We need to have the land use, we need to have physical planning on board, we need to have a lot of other key issues so that we can achieve the socio-economic development and then the environmental issues. So we need also to look at that. That's why the global land administration kind of management is good, and that's why most of the countries are adopting it, because we have everything embedded into one layer. You can relate on what is happening, if it is a forest area, if it is a gazetted area, if it is like recently they are promoting municipality to cities. So, and you find that within those promoted nearby cities, we have customary kind of nature of tenure. So that's why we need to incorporate all that for also infrastructure development. And also we have another question is about the different tools we have today. We have Slack, Open Tenure, we have STDM, and then a tool used by GIZ Transport. For me, from my perspective, I look at them as other surveying tools which they use in the field. So long as you capture your data in the manner that will be allowed into the Uganda NLIS for subsequent transaction, it will be a good way to go. And how can we use the existing efforts by the ministry to improve on to have a common base for all the mapping and surveying works? I think that's the way to go. And also there's a question about, is there a geo portal for the Uganda NLIS? Yes, it is there. However, we are waiting for approval from management, but we are first looking at the corporate clients for having a corporate portal, and then having a public portal for tracking public transaction, that you can go on these portals, see how far your transaction has gone, how far, at what stage, what is pending. And for the corporate people like the banks, we're looking at how can we ease of doing business for you to acquire a mortgage in the bank and some other corporate bodies and other government institutions. So when we look at all these benefits, we want the customary tenure to tap into all these new innovations. So I think there's another question: to what extent as fit for purpose tool helped in registering of CCOs? Yes, to a great extent, because we have been able to capture more than 10,000 CCOs. So if we look at that and we use this tool to support in the data collection, but using the efforts which are available today, it will help us to register or document more land rights and achieve the tenure security which everyone wants to achieve. Because when you look at if we capture all this data and migrated into the LIS, and all activities are done at the sub-county, either online at the sub-county, because setting up infrastructure at the sub-county level, or sub-counties, it is a kind of a challenge, but we are looking at how we can have a mobile office into the sub-counties. How can we have a mobile office which will be used by the recorder at the sub-county, and how can we support the area land committee? But still, it poses a lot of questions. How will the area land committee do the mapping? Will the structures of the sub-county change in terms of staffing? And we have some technical officers like cartographers and surveyors and physical planner to help these communities to carry out their mapping for data quality control. All this has to be thought about. So I think that's what I can submit in for now. Thank you very much.
Thank you so much, Mr. Kambugu. I would love that you answer to two quick ones. Mr. Brian Makabai asked, in the National Land Information System, there was a consideration to have a layer for customary land. What is the progress to date in this regard, if it's still an option anyway? So please answer to that. The other is from Jesse. What software tools are you using for digital mapping for the office and field workflows? Maybe lastly, using different tools, the Open Tenure, STDM, Slack, will not be a challenge only if they all collect similar data on ownership and GPS embedded in each work, roughly in a similar accuracy bound. That was a comment, but please answer to consideration to have a layer for customary land. Is this still happening? And the software tools you're using for digital mapping for the office and field workflows.
Thank you very much. About the customary layer into the Uganda LIS. Yes, we developed a workflow to migrate all this cadastral layer into the LIS, but the only challenge that is incomplete, we need to link the parcels plus details of the registered owner or the registered owner, be it a natural person and a legal person. However, there are a lot of, when you migrate this data because of because of the different methodologies used in data capturing, the accurate survey equipment vis-a-vis the mapping, the tablets we use, you find that there are a lot of challenges. So in the technical challenges, the topological constraints, you find that they're not well achieved. That's why it brings us back that how can we achieve having in the same area, someone cannot come and apply for a freehold where the customary certificate of title is existing. So we are trying to achieve that, but now we can migrate. We tested out some data from GIZ, so we shall be able to also migrate other data. The software that we use for mapping, for us here, as for the Slack tool, we use the QGIS in the field for mapping, and then we have developed a web interface where we link the parcel with the legal person. That's in the Slack tool. So that's when you look at other tools, I think STDM, I think also is using data approach, and I'm not very sure about the tool used by GIZ, but you find that all these data collection tools, they are using open source softwares, which we need to more customize, maybe to meet the requirements of capturing customary data in the field and then in office operations. Thank you very much.
Thank you, Mr. Kambugu. Just a thought to you from Sarah Kusima. She says, Mr. Kambugu, I would rather that we learn from history to establish the boundaries that there are using the customs of that particular area, have it integrated within our current land law, kind of bottom top, do systematic demarcation, we will then be free to go. Like bottom top, it's knowing what the people want and then working on that. Thank you so much, Mr. Kambugu. Mrs. Sarah Kulata, there were some questions to you. Like Susan is saying, it's clear that there's a difference between CCOs and those promised in the National Land Policy. Many land actors think that the CCO is the customary title. What is the ministry's position? There's another question. In respect to the selective implementation of the National Land Policy, can government commit its own funds and ensure progressive implementation of the promises in the National Land Policy? There was a question from Elliot. Who's responsible for land protection? The rights holders are usually denied their rights, especially women and girls. We must work with elders and kings to manage customary land issues. That's a question and a comment. And maybe the one of Mr. Samuel Kasirie, where he talks about, the question is the framework of customary land registration skewed towards making it easier for land transactions? There's almost nothing about protecting land rights. Please pick those questions and comment on, and let's hear from you on that.
Thank you very much, Mr. Chair. Let me start with Douglas Sebagala. he says that customary land titles were made in 1958. I want to make it clear that 1958, the law then did not recognize customary as a tenure. So the titles which were made were termed adjudicated freehold. Freehold in that ownership is in perpetuity, but it was not customary, but it was done on customary land. So those examples I gave of Rujumbura, Igara, Bushenyi, they are adjudicated freeholds. Susan, yes, there is a difference between a CCO and a certificate of customary title. Right now, the law, the Land Act provides for a CCO, and it also provides that one can upgrade from a certificate of customary ownership and have it converted to freehold. However, the National Land Policy, which was put in place after, is the one which proposes that government should take steps to make the certificate, the ownership of customarily at par with the other tenures. So that's why at the end of my presentation, I said there have to be laws, legislative reviews and regulations in order to implement these proposals. Yes, Susan, you are right, but we have to make laws. Mr. Opio Francis, you are saying some customs give land to the eldest son through inheritance. I want to assure you that the law right now says customary law and ownership, customary ownership is recognized. However, and it says that it's according to the customs of a given area. And however, the law states that such customary rules and regulations should not be repugnant to natural justice, equity, and good conscience, or being incompatible with either directly or indirectly with any written law. You know the Constitution provides that any customary law which denies women, children, or persons with disability access to ownership and use of land is null and void. So yes, they will take when the area land committee is determining the ownership of this land customarily, they take into account those provisions of the law. If they deny women, if a family had only girl children and you say girls can't inherit, that is repugnant. So the area land committee may not recommend registration of this land for a certificate of customary ownership into the names of another person other than those people of the family. And that is Opio Francis. Abba Susan Mildred, you say key issues to be answered in regard to customary land titling is how different is recordation and documentation, and is now registering under the other three tenure systems. What endpoint are we looking at? Yes, when we are registering customary, when the proposal to register customary land, we take into account the customs of a given area. And if you look at the form that is used to gather information, to collect information under systematic demarcation, it has all these. How did you acquire this land? Is it this land, family land? How many people are on it? Are you married? With how many children? All that information is collected. So there is people should not be worried that this information will be used against the other family members. No, it is used to protect all the people who depend on that land, who own that land customarily. And Freda Oroch, please don't be fearful that because land is used profitably, people who are saying let's document ownership want this land to be stolen. When we are born, this information is documented. When we die, information is documented. When it rains, information is documented. There is nothing wrong with documenting information regarding ownership. After all, land is a factor of production. So you can improve on your land if you have proof of ownership. You can easily use it as collateral, and you can easily pass it on to people of your own choice, according to the customs and rules of the area. So there is nothing, people who had their land registered in 1958 under adjudicated freehold have never been denied of their ownership. They are still in occupation, although the land was registered under adjudicated freehold. I can assure you that when land registration was first introduced in the country in 1908, it was resisted. Mailo land registration was resisted to the extent that there was a Batakabu movement. It was centered around land. But now it is embraced. Everyone knows the benefits of having a land title. So even this customary ownership, although some people are fearful, the ministry and everyone has to do a lot of sensitization to let people know that it is for the good of everyone. I think I've answered all of them. Let me turn back the mic to you.
Thank you so much. There was the bit of women and from Elliot, the bit of who protects the women. Yes, that was, did you see? Who's responsible for land protection? The rights holders are usually denied their rights, especially women and girls, and the issue of working with elders and kings. But Rebecca also has something. She says, could Mrs. Kulata please highlight the differences between those documents, the CCO and CCT, and why one is considered the superior form of the other? She directed this directly to you. A superior form of land rights protection. Please answer to that.
Thank you very much, Mr. Chair. A CCO, in my view, is a document of ownership. It is in the mindset of us, the communities, the people who think that it is a lesser form of tenure. One, because its boundaries are not on the cadastre, as Judith was saying, because they use a sketch map. And then two, the ownership is according to the customs and regulations of each given area. It would mean that whoever wants to deal with that document would have to be conversant with the customs and regulations of that area. I'm from Busoga. So if I'm to deal in land in Kabale, it would mean that I would have to ask, these customs and regulations are not documented. That's why I was saying that there has to be laws and regulations enacted to govern these transactions. It means that I would have to find out, research on the customs and regulations of land, how land is dealt with in Kabale before I can deal with it. If I'm to cross over to Karamoja, the same. So because there's some gray area to a third party, that is why people think it's a bit of a lesser tenure. But it is, the Constitution says it's at par. There are 4 tenure systems. And women and children are protected. When we are gathering data before registering a CCO, these issues of gender are incorporated to the extent that when we did systematic demarcation in Lukarango, after the demarcation, moreover, when we are doing the demarcation, the initial demarcation, we use the local markstones that they use in the area. And then those local markstones would be painted red or any other color. And then the surveyors would come later and put markstones. And still they would leave the local demarcations in place the local mark stones. But surprisingly, after survey, people opted for certificates of freehold. Why would people opt for certificates of freehold and not a certificate of customary title? We have to do a lot of sensitization on that so that we make it known that the certificate of customary title is as good as the certificate of freehold, is as good as the certificate of Mailo title. I think that answers that, Mr. Chair. I'm sending the mic back to you.
Thank you so much, Mrs. Kulata, for the extensive deliberations on that. For any other questions that will keep coming in, I'll pass them on to the responsible panelists, and they will also keep looking into the chat window because then they are responding to some of these questions. We realized that some of the people were not seeing the poll when it's launched. Please, and it made it hard for you to answer back to the last two polls. So I'm going to send them. Please look at your taskbar. I'm launching the poll for the second presentation, which was done by Judith, and it talks about learning from the past, emerging spatial issues in customary land registration. Did you know about the spatial constraints in registration of customary tenure? So that's the poll I'm launching now. When it's done, I'll launch the third, which was the presentation by Mrs. Kulata, because many of you expressed concern that you were not seeing where the poll, where the poll is indicated. So please, I'm launching it now so that you respond to it, and then I'll be launching the third poll. Thank you. So going forward, Mrs. Sarah Kulata, there's just one question for you that you could answer to, and then I'm going to have a question for all the panelists. Going forward, the question to Mr. Sarah Kulata is, do you think it's logical and not duplication of effort to have all the different stakeholders to map land for issuance of CCOs, and then have a provision to still convert land from customary to freehold? Doesn't this imply to people that the freehold is the ultimate protection of land rights? Please clarify more on this, even though you have slightly hinted on it. You talk about having a registry, but you also talk about conversion to customary tenure. Doesn't this make freehold seem like the ultimate protection of land rights? Please answer to that, and then we'll get to the final question for our panelists.
Let me start with the last. Converting from CCO to a certificate of freehold title is a creation of the law, the 1998 Land Act. The framers of that law thought it best that should be the case. When you convert, the element of converting involves survey, that the boundaries and coordinates must be captured, and then it would enter into the national cadastre. Because as that cadastre of Mr. Kambugu, as it is developed now, is developed on having fixed boundaries, known fixed boundaries. So that is why there is that. It was provided in the law. However, years after the enacting of the law, the National Land Policy was put in place, and the policy says it recognizes that we have 4 tenure systems, and it recognizes that the community, people take customary tenure to be of a lesser value, of a lesser tenure. So then there are strategies towards equating customary tenure with the other 4 tenures. And one of them is to have a customary land registry, and also to sensitize the people and involve the customary elders and chiefs in registering this land. Because when you do, then people would embrace customary land tenure, and people would not fear and would not think it is of a lesser tenure. For you to bring something new in a given area You have to do a lot of sensitization, and you have to do it with the participation of the community concerned. In 1902, when the colonialists gave out land, when they were implementing the allocation of freehold of Mailo land in Uganda, they involved the chiefs and king. They involved the king and the chiefs. And that's why Mailo land came to be registered. So if you are going to a given community, which has stayed there without having any document of ownership, and for them it is okay, you have to involve them to see that you are not introducing anything new, to see that you are recognizing their ownership and the boundary, and you are just marking them. And you know, after mapping, you also display a map and you explain. They get very excited when they see their land on the map. Oh, this is mine. Actually, this is where the tree is. What? They get very, very excited. When we did it in Busoga, in Uganda, the land is measured according to sticks. We call it nigo, sticks. So when people went to the map and saw the map drawn, they got their sticks and went back and did the sticks. And they said, yeah, they captured it well. 10 sticks to 20 sticks. Then you converted that in meters. And he looked at it at the map. He said, yes, it is correct. Now we can go ahead and get a title. That is making the community embrace what you are doing. You cannot register land customarily without involving the owners of the custom, because it is those people who will tell you that customarily this land belonged to so and so. Customarily this is clan land. Customarily for grazing, it cannot be owned by an individual. Or this land is for the family of so and so. So we have to involve each stakeholder for them to appreciate and embrace the program. Thank you very much, Mr. Chair.
Thank you so much. Thank you so much for the elaborate discussion that we've had regarding these conversions and also the registration of customary tenure, especially from the legal perspective. I know now we're getting short on time, but we want to get to the last segment of this discussion and of our webinar. We have looked at we've had a snapshot of the ongoing initiatives for registering customary land by Mr. Kambugu, where he has talked about the different tools, where he has talked about the migration of data from those different tools to the land information system, where he has talked about integrating the data, integrating the registers for the Mailo, freehold, and leasehold together with the customary system, the customary registry that we are proposing here. We have heard from also Mrs. Sala Kulata. CCOs are not CCTs, the certificates of customary ownership are not the certificates of title of customary land. The proposals in the National Land Policy. We've also seen the contention regarding registering interest in land. So these are all the discussions, especially around the contemporary legal and spatial issues in Uganda. Legal, regarding the law, and spatial regarding now the actual registration and the interests involved in this registration. To our panelists, I want to come up with the last question, and I'll start with Mr. Kambugu. It's going to be the same question to all our panelists. Getting into the future, now that we are having this discussion on the customary land registry and laying the foundations for registration of customary land. So for the future, what, with all these legal and spatial issues that have been identified, Mr. Kambugu, what are your ideas for future action, especially with a comprehensive land information system and also the legal framework around it? What are your ideas for future action around laying the foundation for registration of customary tenure in line with the spatial issues identified?
Thank you very much, Mr. Mweve John. The future of how the management of the customary tenure is that to come up with a customary register within the National Land Information System, as we did for the other 4 tenures. If we are focusing on the land tenure, land value, land use, and land development, because all these have to talk to each other, because in these areas we have a mix of tenures. So we cannot have a different land register of customary, and then we have a different system for other tenures. It will have an impact on sustainable development. So as I think from the legal perspective, they should think of how best can the customary tenure management be achieved based on the current trends of development, the current trends of land administration and management perspective. We should have a customary register integrated with all other registers to make a more efficient land management and administration system. Thank you very much.
Thank you so much, Mr. William Kambugu, for that succinct presentation and for your views on how you think the future holds and the ideas for future action to ensure that we lay the foundation for registration of customary tenure. Before we have the submission from Mrs. Kulata, I want to put out the third poll. This third poll is with regard to the presentation that Mrs. Kulata did. It says, do you feel that the current legal framework is sufficient enough to protect the land registered under customary tenure? I repeat, do you feel that the current legal framework is sufficient enough to protect the land registered under customary tenure? It's a yes or no. Please, I've launched the poll. Let's have the polling. So to you, Mrs. Sarah Kulata, still talking about now the future as we lay the foundation for registration of customary tenure. What are your ideas for future action? We've seen the intersection of the legal issues, the legal framework, and how it speaks to what is happening on the ground where registrations are done, conversions of land are done, but also where we have both is the tools. So how will all this data be reflected and in the registration?
In these 3 phrases, it's just nomenclature. When it comes to what the defining the nitty-gritties in each, they are the same, with the exception of customary tenure, that it depends on the rules and regulations of a given community. My view is that these rules and regulations should be known to make it more transparent for everyone dealing in this land. 2, because rules and regulations, customs are never static, they change. And the customary tenure has over time changed towards bigger clan, tribe to individual. So if we write these rules and regulations, document them and codify them, won't we be locking those customs? My take is that yes, as we are thinking of having a customary land registry, let's know that a certificate of customary title is the same, will be the same like a certificate of other tenures. Because when you look at the law, it says an owner of a certificate of customary owner can sell, can mortgage, can will, can what? The same that can be done with the others. So we really have to take a bigger step and see where we want to go. But I support the registration of all customary land so that people have their document of ownership. Thank you very much. Back to you.
Thank you so much, Mrs. Sarah Kulata, for what you see as a way forward or ideas for future action. For Judith from LandNet, please, with regard to the issues that have been raised, especially spatial issues relating to registration of customary land, what do you see as future action? What those actions for the future that would make possible the registration of customary land? Please take it on.
Thank you very much, Mr. Mweve. Parting shots from the spatial framework is that, like I discussed earlier, the kind of system that we have in the other three systems that customary tenure needs to be at par with, there are certain standards, requirements of accuracy that need to be adhered to, or need to be established for the same, for customary tenure to be able to be at par. This includes the reference systems that you use, the decisions. We already have a geodetic reference network, so we can tap into that potential that we have now for us to establish something like that for customary tenure, or to have customary tenure surveyed. But we also have to keep in mind the kind of nitty-gritties, the kind of organization and social fabric of customary tenure, how the land is owned, and how we can survey that land in a nature like that, in an organized manner, as what is uncustomary. So these systems are already there, yes. The law now needs to be streamlined, like other panelists have also talked about. We need to streamline, but also make sure that we have standards, like the other tenure systems have, standards of planning, standards of minimum subdivision, standards of parcel surveying and demarcation, yes. So that is what I would say, yeah, as a parting. Thank you very much.
Thank you so much, Judith, for that, for your parting shots. I know that we are coming to the end of this webinar, and I want to make one communication going forward. We're going to be following up with a survey for a deeper engagement on the need to have customary land registered. The discussions that we're having are building blocks for the bigger picture of laying a foundation for the registration of customary land. I know that the discussions on registering customary land are full in the public domain, because then the demand for land and the way transactions on land are going, especially in the current times, is quite appalling. If there's anything that's at risk, it's especially the common lands. So let's have this discussion going, and let's see how we will build upon the efforts that we have now to see that we in the near future further the discussions, especially within government, of the registration of providing support to the registration of customary land. I want to invite Mr. Jonathan Ochom to also give a remark. He's from LandNet, to give his remark and to have an end to this webinar. Please welcome Jonathan. Okay, he could be facing some challenges with his internet. Well, thank you so much for making time to be a part of this discussion. It's been a very, very helpful. It's been great that you took off your time to be a part of this discussion for the entire 2 hours. We will keep communicating the different levels of this discussion. We're going to have multiple webinars that will be held, so that then we can, this all culminates into support to the ministry to be able to figure out the development of to figure out if we really need to have a customary land registry developed, and if we do, then it will be, all this information will feed into the development of that registry. From LandNet, we wish you all the best, and thank you so much for making time for this webinar, and have a great evening.
Thank you.